No, good morning. So we had been looking at some of the legal issues that you have to consider when publishing stuff online. And we had looked, first of all, at libel, mostly, which is important. And we had also looked at copyright and how copyright worked. And the purpose of copyright is to encourage and to support the production of creative works. So if you could just copy people's books, then they wouldn't make any money, so they probably would have to stop writing books. So it's a contract between society and creators. It's facing challenges at the moment due to technology and the ease with which things can be copied and distributed. The Digital Millennium Copyright Act was passed largely in response to things like Napster, which did not in themselves copy, but allowed other people to copy. And so facilitating other people to copy became an offence, and also hacking digital rights management is in itself offence, even if there's no copyright infringement per se. We saw also the printer case there, and we had a look at fair use. Did we discuss fair use? So in the US, there's a principle known as fair use, which allows people to make limited copies or copies of portions of someone's work for scholarship or for commentary. So if I was to discuss with you the writing style of J.K. Rowling, I might, for example, print 2 pages from a Harry Potter book and circulate that around. And under the fair use doctrine which you'd have in the US, that would be a reasonable thing for me to do in that context. There's no actual definition of what constitutes fair use, but the amount of stuff that you copy is considered important. And of course, the effect on the use that on the potential market for the product would be considered. So if I copied the last 5 pages of a Harry Potter book, the one where all the action happened or something, and this person got killed and that person got turned into a frog, whatever, that those last 5 pages might be so important that my distributing them around willy-nilly might in fact have an impact on the market for the original work, in a way that maybe, 5 separate pages from different parts of it might not. So those are things that would be considered. So this work here, this collage by Richard Hamilton, is called Just What It Is That Makes Today's Homes So Different, So Appealing. This is from 1956. I didn't really mention, or didn't explain properly, that of course copyright also applies to photographs. And in general, the photographer owns the copyright to a picture that he's taken. Now, Hamilton did not take the picture of this bodybuilder here. He did not take a picture of this lady here. He did not draw this cartoon here. This is a collage made from things cut out of magazines. And this is widely accepted as a new kind of work, that he's made something new out of the old things. So just as 200 years ago artists may have gone out to the countryside and their work might have been their personal response to the landscape around them, in the 20th century and in the 21st century obviously, much of the landscape that people experience in urban environments is the media landscape. And so many artists take their inspiration from that and create new works in response to the media landscape around them. And this, in 1956, magazines would have been a very important part of people's lives. And it's also an interesting time in history in terms of the beginning of consumerism and stuff like that. So this would generally be considered quite a reasonable thing to do. The photographer that took this picture and this picture, the cartoonist that drew this, they weren't going away suing for copyright infringement. There was a very interesting case very recently in the US where an artist was also using photographs belonging to someone else, and that resulted in a big court case. And the artist lost, I think, and the original photographer won. But in general, something like this would be considered okay. It's interesting, though, how in music we don't take the same approach. If you create a piece of music using snippets from all over the place, we seem to have accepted that the creators of those snippets are entitled to some of the money too. And we're all familiar with, you know, celebrity sampling cases, and this person suing that person. So it is interesting how we've taken a different approach in music than we have with photographs and art. So this fair use doesn't apply outside of the US, but as a principle, it's been around for a while. Now, copyright is the main way that software makes its money. So if you're in the software industry, you more than anyone should be respecting other people's copyrights. So the idea was that you would write your software and you would distribute it, you know, as copies, and then every time someone was given a copy, they would pay you. The internet, of course, has made that interesting as well. It's very easy to copy software and distribute it. It always was really easy to copy it because it was always digital. But obviously it's much more easy to distribute software as well now. So we've seen a sort of a move away from copy-based revenues to subscription-based revenues. So if you take Photoshop, for example, which you use for editing images, you've seen that in the labs. I'd say Photoshop must be way up there with some of the most pirated software. And Photoshop is moving now towards a subscription-based model where you pay per month to use Photoshop rather than buy it and have it and own it outright. We also see in mobile phones the idea of a game where you, obviously we have games where you might pay €2 or €3 or whatever to download them, but a lot of games are free and then you pay for the extras. You choose to buy extras, you choose to buy a cow for your farm, whatever. And that's largely, I think, these new models are largely in response, I think, to the challenges of enforcing copyright. And so we've new ways of organizing for people to get paid for the work they do in software. So I think if you were to sit down today and say, well, we're going to write some programs and we're going to make lots of money from those, you probably wouldn't even be considering copyright as the way to go. You might just assume that's not going to work for you. And you see it with websites as well, where you pay a monthly fee to use them, whatever. So as things move into the cloud, the authors have a more control over who gets to use them. So you control the access to the software, and then you just host it, and people pay you then to use it. So it's interesting to speculate whether the move towards cloud computing is entirely a technological evolution, or is it also driven by some market forces, because it's harder to get your money from copyright. The expression public domain is sometimes used loosely in the vernacular to mean something that's commonly known. So, you know, if a politician says something and people say, you shouldn't have said that, he might say, oh, well, you know, that's in the public domain. People already know that. In intellectual property terms, something is in the public domain if there are no intellectual property rights associated with it. So that may be because if they've expired. So the earlier works of Arthur Conan Doyle don't have any copyright on them because the copyright has expired. Shakespeare is long dead, so you can do whatever you want with his works. Over someone who isn't dead 70 years, those people's work would still have copyright associated and wouldn't be in the public domain. There's a movement called open source, and this is all about people working as a community on a software project or some other big project in order to produce a solution that's given away for free. So the most notable examples would be OpenOffice, which is a free version of Office software that's compatible with Microsoft Office. So if you don't want to fork out the money for Microsoft Office, you could download OpenOffice. And we also have open source operating systems like Linux. So those are the successes. You don't hear about the open source failures so much. Another good one would be the GIMP, it's image editing software, and that's free also. And typically people, because they're interested or care passionately about something, would contribute their time freely towards a software project, and they might check out some code, improve a piece of it, check that back in, and you have some people that are sort of sitting in the middle, just keeping everything organized and keeping track of versions and stuff. Many of the people working in open source actually have day jobs, and their employers allow them to say work on it 1 day a week, for example. Their employers might decide that it's of strategic importance to be involved in this. So there are some notable successes, but it only works, I think, for high profile projects where there's a bit of glory to be had. You don't see it so much for the really boring stuff. Another good one actually is software called Handbrake. It converts video from one format to another. That's open source as well. Typically with an open source product, you can download it and improve on it and do what you like, although there tend to be different kinds of subscriptions. Some people are quite happy to surrender the intellectual property rights that would be associated with their work straight away. So an organization or a community called Creative Commons has produced a set of licenses that allow people to specify exactly how they would like to share their stuff. So if you take my recordings of classes, for example, I'm quite happy for anybody who wants those to copy them if they wanted. Wouldn't bother me. I wouldn't be so keen if someone was to take them and chop them up and remix them and do stuff with them. I'm trying to think, you can have them, but take them as they are or leave them alone. So depending on what you're trying to do, there are different kinds of licenses. So if you're looking for an image, for example, for your newsletter or for your blog or for your website, you will be able to find images where the photographer has decided that he doesn't care what you do with them. You can take them, edit them, do what you like. Others might say, you can use this image, but you have to give me the credit for taking it. And so that person is happy for his or her images to be out there as long as people are clear that, you know, this is the person that took them. And that person then might, you know, get more traffic to his website, whatever, might be happy with that. Whereas the default setting, if you take an image, just because you put it on the web, it's yours and no one is entitled to copy that. So the default setting is that there's a copyright on that image and it's going to be in force until 70 years after that guy dies. So when you're using images on the web, for example, you have to figure out if there's a license associated with those that might suit you. So Creative Commons helps with this by having produced a bunch of standard licenses, and you can pick the degree of generosity you want to bestow on the world. So that's worth having a look at. Image search databases like Flickr, for example, will let you search just for images that don't have copyright associated with them, if you wanted to use them for something. Okay, so that's worth having a look at. Now, so that's copyright, which is certainly the most important thing you need to consider when you're publishing online. Over this class and the next few classes, we're going to look at some other kinds of intellectual property, which may also be relevant, but not so much. What's really important, though, is you understand the difference between copyright and these other things. So we're going to look at copyright, patents, trademarks, and trade secrets. 4 different kinds of intellectual property rights. So next up is patents. So a patent is a set of exclusive rights granted by a national government to an inventor in exchange for disclosure of the invention. And this right prevents others from making the invention, using it, or selling it, or distributing it within that territory. And it typically lasts for 20 years. So copyright is applied to creative works. Patents are for inventions. Now, you know, is Harry Potter an invention? I mean, J.K. Rowling invented Harry Potter. So we need to make the distinction between creative works and basically technological, scientific works. In the past, that was very easy because an invention was a physical thing. You know, you could have your machine for thrashing corn or wheat or something. You know, and it was a physical device. And a book was clearly a creative work. It was just words. But of course, software has made this a bit complex, because we can have inventions now that live just inside the machine, and there's no physical, tangible thing you can hold in your hand and say, look, here's my invention. So that has been an interesting development over the past number of years. Anyway, the basic idea is you make an invention, you invent something, you have a new way, say, of making beer that uses half as much water as the old way. You have a number of options. You could get into the beer making business, and you might do quite well for yourself because your water bill is lower than everyone else, and so you might save some money. And you could keep it a secret, and that'll be your secret. A patent would encourage you to tell the world how to make beer using a lot less water. So you could you could patent your process. And you would do that by applying to the patent office and explaining how one goes about making beer using less water. Then no one else would be able to use your technique or use your invention for 20 years. So you'd have 20 years to try and make some money from that. You could, for example, license it to Guinness or, you know, to some other beer making company, and they might pay you a royalty for that. So you needn't get into beer making yourself. Once the 20 years is up, anybody could use your invention without paying you anything. But you've 20 years to make your money back. Patents are the main mechanism by which the pharmaceutical industry works. So researching a new kind of drug and developing it, and even just testing it, even if you know it works, even just testing it and getting FDA approval, that can cost millions and millions and millions and millions of dollars. So it can cost a fortune to get a drug to the point where it's ready to go on sale. Once it's on sale, we know it's safe, we know it works. Any competent chemist could probably analyze it and tell you what's in it. And so they could easily then reverse engineer the recipe for manufacturing it. So having spent millions and millions and millions to bring your drug to market, someone could set up a factory down the road and make it too, if we didn't have the patent process. So what patents do is they give the drug companies an exclusive right to make that drug for that period. And that's necessary because otherwise drug companies wouldn't be able to make back their money. Now you do hear then people talking about the evil bastard drug companies, you know, selling a drug for €50 a packet when it only costs €5 to make. But that doesn't factor in the millions that were spent in advance to get the drug to the market. It also allows, and I think this is something that's very often overlooked, it also allows small entities to be able to make some money. So let's say, for example, you invented a new way that could make mobile phone data go more quickly, say from A to B, or more cheaply. So you have some invention that lets you make voice calls much more efficiently. That's great, but it's not practical for you to get into the phone manufacturing business. I mean, how much money do you need to, you know, commission some factory in China to build, you know, millions of your phones, and then you have to go selling them? You can't get into that business, most likely. You've to finish college for starters, you know. So the patent process also allows very small entities to exploit their inventions because they can license them to bigger companies. So if you're a small drug company, you can license your drug to a larger drug company that can more efficiently go about the business of manufacturing it and selling it and marketing it and stuff. So an important part of patents is that they allow the intellectual property to be transferred from A to B, you know, from one entity to another. There's a market there, and you can extract your value from it that way. There are some ethical issues, I suppose. You can imagine if a drug company needs to sell its drugs for €50 a box, even though it only costs €5 to make, in order to get back its money. That's fine in the developed world, but in the third world, €50 a box might be an awful lot of money. And it's very hard if someone is going to die to say, well, you know, we have to respect intellectual property rights now. It's the bedrock of our, you know, industry, and you can't just go around willy-nilly allowing anyone who wants to make the drugs for free. So many drug companies and the European Parliament, I believe, have set up a system where in third world countries the licenses are granted to local companies more cheaply and things like that. Certainly it's hard if people are dying, you know, to say, ah, well, you know, you can't make it even if it only costs €5. In India, for example, the government there is inclined to not grant patents in some cases, or there have been some issues with patents in India, so that local drug companies can make the drugs without having to pay the royalties. But then in a global economy, then you have, you know, porous borders and all sorts of problems. But it is an interesting question, you know, do you let people die? In the patent system, there is a social contract, really, between the inventor and society. So society is saying to inventors, please tell us about your inventions so that we can have the benefit of them. Because if you fall under a bus tomorrow, we'll never know how to make that drug, or we'll never know how to make that beer without using so much water, whatever the case may be. So the inventor gets the monopoly in exchange for the disclosure. And that disclosure is important. So I'm saying, I've invented this cool thing, can I have a monopoly to stop other people from using it? Well, yeah, but you have to tell us exactly how the cool thing works. And so there are standards in place for the degree of disclosure. And the disclosure must allow any person competent in that field to understand how it would work. Obviously, there's no point explaining to me how to make a particular drug, but you have to describe it in a way that a chemist or pharmacist could make that drug. Okay, so this is exchange here. And that's important. Like the contract between society and the creator, you keep creating works, we'll respect your copyright so you can keep doing that. So patent then has a number of parts. And this slide here is from the European Patent Office. I don't know if it's made up or if there really was a patent involving this two-spouted teapot. But it does show you the different kinds of things you would have in a patent. So the first thing is the prior art, which is the state of the art up to now. So we have a way of making beer now that's quite efficient. Here, the prior art is a teapot with one spout. Now there's a problem with that, there's a drawback to it, it's time consuming. And this invention here solves the problem. It reduces the time it takes to fill teacups. And it does that by having a second spout in the teapot, and the advantage then is that you have multiple cups can be filled at one time. So it's an advance on what was there before. And that's important. There must be some inventive step, there must be some new thing that it does. And it must be non-obvious as well. Now, patents and the criteria for granting them vary from country to country, but there has been a lot of harmonization of late. So, to get a patent is very different from a copyright. Copyright subsists as soon as you create the work in tangible form, you have the copyright. A patent you have to apply. So you apply to the patent office in the jurisdiction where you want the patent for. And you outline in detail what the invention does. And then at some point in the process, your patent application will be made public. People may have the opportunity to comment on it. People may have the opportunity to challenge it. Might say, actually, no, look, that's not a new invention. Some guy in Norway did that, 6 years ago. Here's the evidence for that, whatever the case may be. But it's a process. And the different kinds of things that can be patented then will vary from country to country. You must apply for your patent on a country-by-country basis. But the European Patent Office simplifies that within Europe. So the European Patent Office acts as sort of a clearinghouse where you can do a batch job and get 20, 30 different countries worth of patents in one go if you want. Now they still go back to the national, it's still a national patent you get. And it's open to challenge in national courts. But it does streamline the process. Interestingly, it extends beyond the EU. So you can apply for a patent, and you can say, I want it, in Ireland, the UK, Belgium, Norway, for example, Bosnia, and Turkey. You can even get your Turkish patent via the European Patent Office. But at the moment, you still only get patents on a country-by-country basis. There are plans in the future to get an EU-wide patent, where you would apply once and get one that would have effect across all of Europe. We will need a referendum to amend the Constitution to allow that to happen. It'll probably fly under the radar. We did something like it many years ago, and no one said boo, there was no discussion of it. Probably the next time we have a referendum on amending the Constitution, there'll be changes to marriage rights as well. So again, it might not get much airtime. But for this new single European patent to come into effect, we'll need to change the Constitution. Now, this is an interesting question then. In which countries should you get your patents? Remember, it costs money to file for a patent. You have fees to the patent office, but you also have to pay lawyers, things like that. So you might decide, well, I'm not going to go and get it done in every country. Oops. So I don't die off this chair. No. So have you seen this horloge? It looks like a hurley, but it's actually foam. It's soft. Now you still get quite a clatter off it actually if you give someone a wallop, if you get a wallop of it. But it's for kids to play hurling without sending each other to the hospital. So there's a patent on this in Ireland. So this can't be manufactured or distributed or sold in Ireland without the permission of the patent holders. Now, they probably don't have a patent in Germany. Would you think it's worth their while? I mean, without a German patent, people in Germany could manufacture these hurleys and sell them and do whatever they want. No, they couldn't ship them to Ireland. They couldn't export them to Ireland, and a shop couldn't, buy them in and sell them in Ireland. Do you think it'd be worth their while getting a German patent? No. I mean, how many hurleys are you going to sell in Germany? Like, not very many. Similarly, if you figure out a new way to make snowmobiles more efficient, you're probably not going to bother with an Irish patent. Like, how much money are you going to make off snowmobiles in Ireland? Like, let's face it. Unless now there was some major snowmobile manufacturer going on, which there isn't. Okay? So depending on what your invention does and the likelihood of exploiting it in a particular jurisdiction, you might or might not bother with a patent from that place. Also, some countries might just be, the market there might be just too small. So you might decide that for your super new cool invention, you get a patent in Europe, a patent in the US, a patent in Japan, maybe a patent in Australia, and a patent in China. And you might decide you're not going to bother with Ecuador. So people in Ecuador will be able to do whatever they want, and you won't get any money from your invention in Ecuador. But it probably won't bother you, because they won't be able to export it to the US or export it to Australia. So they're not going to interfere with your rights in that territory. And so a lot of companies would be doing that. They wouldn't get patents for everywhere. And certainly I think a UK patent for this horloge would make sense, because otherwise they could be imported into Northern Ireland, which might not even in itself be a huge market, but it might be difficult to stop the ones that are on sale legally in Northern Ireland from spilling over the border and interfering with your profits there. And also you might sell quite a few of them in the UK, but certainly you're not going to sell many in Germany or Italy or wherever. No. So patentability then is also going to vary from jurisdiction to jurisdiction. In general, only certain kinds of things can be patented. and the invention must be new, or some part of it must be new. In the US, it must be non-obvious, and in European patent law, it must have an inventive step. So in general, it must be the kind of thing that's allowed to be patented, and there must be some novelty there. In Europe, some things are specifically excluded from being patented. So a discovery or scientific theory or a mathematical method, you can't get a patent on that. Aesthetic creations, you know, something that looks nice. I mean, that's a copyright thing. Maybe I get some copyright protection for that. But if you have an invention, but really all it is something that's pretty, that doesn't count. That's not patentable. Presentations of information aren't patentable. And then schemes, rules, methods for performing mental acts, playing games. Now, are doing business. That's one that can't be patented in Europe. In the US, you can patent business models much more easily. In Europe, there must be some technical effect. There must be some technical part to it. And then programs for computers are specifically prohibited from being patented in European patent law. And that's very interesting because the Patent Office routinely grants patents for software. And so we'll see what's going on there in a minute. There are also some things that may not be patentable just because they're immoral. So if you had a new way of killing people more efficiently, you know, if you could, you know, instead of killing them one at a time with bullets, you could do 20 at a time or something. You might find that the Patent Office decides not to grant you a patent on that simply because it's immoral. But again, there are, you know, fairly specific standards there. The programs for computers are an interesting one because European patent law has it's defined in a convention that was signed about 30 years ago. And at the time, it wasn't possible to foresee how computers would become embedded in everyday things. So you can't patent a computer program all by itself, but well, first of all, it's very, very complicated, and we can't go into it in detail here. But you can imagine how if you had, say, a new kind of engine that was much more efficient, there may be a part of that that involves software. And so the Patent Office took the view, well, you know, if the invention by itself is good, the fact that there's some software in it doesn't render it unpatentable. It's gone a step further then. If you have something in the computer that has a technical effect on the computer, so if you have a software invention that say makes the computer go faster, or if you have some software invention that allows data to be transmitted more efficiently, if there's some technical effect, then it's probably patentable. Whereas I have a computer program that does this cool thing. If that cool thing doesn't make the computer, you know, faster or better or stronger or fitter, then it's probably not patentable. It's very hard to figure out exactly where the line is. You'd need a bit of training for that, which I hasten to add I don't have. As a general rule of thumb, I like to imagine if the invention was so cool that they had to put it in all the textbooks, which textbook would it go in? So if it was going to go into the architecture textbook, then yeah. If it was going to go into the telecoms textbook, then probably patentable. If it was going to go into the e-business textbook, well, then maybe not. I think the hardest one is probably if it goes into the HCI textbook, is it patentable or not? I mean, when I do the swipe here on my iPhone to unlock it, is that a technical thing or not? That's a harder one. But certainly if it makes the computer run more efficiently, even if it's only in software, it's patentable. Now, there are some people then who take a more absolutist view, and particularly people who are involved in open source. And they take the view that no, it says you can't patent programs for computers. It's there in black and white, and you're basically, you know, having a laugh, and you're just breaking the rules, breaking your own rules. And so there's been quite a lot of debate. It's actually quite controversial. Another problem people have with open source is that, or another problem that the open source people have, is if you're writing a program, you're donating your time for free, and you're going to give the program away for free, and then it turns out that that program infringes a patent somewhere, well then you won't be able to give it away for free. And so some open source projects have fallen afoul of patents. And we saw when we were looking at GIF that the main reason we got PNG in the first place was that there was a patent on some of the techniques that were used in GIF. And when the owners of that patent were exercising their rights, people got in a tiff and if you forgive the pun, and went off and decided to have their own format. So the programs for computers is a very interesting one. It used to be very simplistic. In the US you could patent software, in Europe you couldn't, but it's much more complex than that now. So like I said, I think that textbook rule of thumb is probably the best way to go, just in terms of thinking about it without wrecking your head. What kind of things do you think might not be patentable on ethical or moral grounds? So you said ways to kill people, for example. They have a problem in the US at the moment. The drugs they use to execute people are from Europe, and we won't sell them to them anymore. So they're having trouble killing people. Yeah, so, well, they find other ways. But if you had a new drug that was great for killing people, and it had no other possible use, you might find that you wouldn't get a European patent on it. Having said that, probably wouldn't have been much use to you anyway, financially, because you couldn't sell it, or you couldn't sell it in the EU anyway. But, so you might just go for a US patent on that. It's a very rare exception, but I think it's interesting in that it does acknowledge that the law, even technical, perhaps dull patent law, is at the end of the day a codification of a society's values. Do you know? Law is just basically society writing down and codifying as best it can what its values are.
Where would firearms figure or feature on that, do you think?
I don't know. I would say if you had a new kind of landmine,
yeah,
you might be told, well, you're not getting a patent for that, sorry.
Yeah, I know like the Americans put out, what's a company called Barrett put out the 50 caliber rifle that's now used by the military worldwide by snipers. But it was like before 50 caliber could only be mounted on a tank or a vehicle.
Right, yeah, I don't know.
Yeah.
You might find, I don't know, I mean, there's certainly quite a booming arms industry in Europe as well, like, let's not fool ourselves. But you might find some things might not be patentable. One thing, for example, if you have an invention that can only be implemented by destroying human embryos, then you might not get a patent on that. We would consider that unethical. But it's a very rare exception. I just think it's interesting that it exists at all, that you can object on moral grounds. Some interesting examples. Amazon has a patent on a one-click purchase. So you can have cookies, and cookies can recognize who you are and that you've been here before. So Amazon recognizing you could say, oh, well, that's Colin Manning, he lives there, his credit card is this, I know all this already. And you can have a situation where I can just press the button once and it's out the gap on its way to me. Amazon got a patent on that. So when someone else then wanted to do that, they couldn't. They had to pay a fee to Amazon. So that was an interesting one and a controversial one. I would think that's interesting on a number of grounds. First of all, I think it's an obvious follow-on from cookies. If you have cookies, you can't but eventually arrive, I think, at one-click shopping. Also, is it really that technical? You know, is it an invention? I mean, it's a clever idea. Is it an invention? And so you might find that, I'd say if Amazon had applied for a one-click patent in Europe, they probably wouldn't have been successful. And I mean, the interweb is awash with controversial patents. The US Patent Office has, in the past at least, granted some patents that we might consider now to have been unwise. One of the problems, though, is that it's very easy in hindsight to think, oh my God, that's obvious. But lots of brilliant things are obvious once you see them, but they may not have been so obvious, you know, until we've seen them, if you get what I'm saying. So it can be hard to 10 years later to say, well, they shouldn't have got a patent on that, you know. Maybe it really was brilliant and novel at the time. So any questions on that? So one of the problems with patents is that in the US at least, there are lots of patents on doing certain kinds of things on the web. And so if you have a website that does those things, you might be infringing someone's patent. And of course, if you can't have US customers, you might be using out on a lot. So that's controversial. And I think in the next class, I'll very briefly tell you what a patent troll is, but we'll move on then to other kinds of intellectual property in the next class. Thanks, guys.